my president will make perhaps better sense. She's senior counsel, and the minister is here. Perhaps he can guide us. But let me start by saying this, Timothy, that justice must not just be done, but must be seen to be done. I think that the display at the General Court Martial leaves you thinking whether the pursuit of that case is about justice or indeed about other things. Now the court is just a stage. Because right from the beginning, there were already questions about the legality of that process. Okay? The good captain talks about military cooperation between countries. The East African Treaty doesn't trump the Ugandan Constitution. There are legal processes for rendition, both under domestic legislation, but under other international legal instruments. The rendition, let me use perhaps a softer word, the rendition of the two individuals before the General Court Martial raised questions about legal processes. Okay? Because he mentioned about Mukulu. Mukulu wasn't in a civilian court in Tanzania. He had been arrested. And Uganda wanted him back. What they did was to follow the right procedure. Not to cite some MOU, but to follow the right procedure, to go before the High Court in Tanzania, file an application for rendition, and in that process comply with international law as well as domestic law. This is the second case of Thomas Koyelo. Koyelo was not in a detention somewhere. He was picked up at a battlefield, nearly, dead. We brought him back to the country, took him before the International Crimes Division of the High Court. One can argue that the nature of the crime that they alleged to have been committed by Thomas Koyelo and Mukulu were crimes of international nature. And therefore, the most appropriate court would have been the International Crimes Division of the High Court. Perhaps that is true. But the question of processes, if you don't get it right, you taint the entire trial. And I think there are questions about legality. The second thing is this, that you have a court process that appears to have been hurriedly put together. Okay? When the president says don't grant bond to people, what I read and what I saw in the newspapers today, the Chief Justice reading, was that before you arrest somebody, better have the evidence so that when you arrest them, you take them to court. You don't have to hold them for long. The question of a bond becomes relevant if the person is being held beyond the 48 hours. And if you have evidence, take them to court. What we see in the General Court Martial is that we are making the case as we go along. Hence the addition of a third individual in Captain Ola, who, by the way, I must point out, has been in jail for the last 2 years. Alleged to have committed a crime alongside these two individuals. One wonders how such a crime would have been committed by an individual who is already in prison. So we are making this along as we go. I think that the predominant thinking has been, there has been such a sustained argument about the trials of civilians in the military court. And I think that the calculation has been that they're just about to lose that argument. And the addition of Captain Ola is to make the case that there's a second limb under which a civilian can be tried before the military court, namely that the alleged crime was committed together with a service personnel. Okay? That, I think, is the only calculation for the introduction of this new offense and for a new accused person on the same charge sheet. Now, my argument has been that we need to reset, because this clumsiness appears to have been both on the side of the court, but also on the side of our colleagues who are defending their clients before that court. I think the primary objective, and I think my good friend Sam Moyizi, who is the legal advisor for the Democratic Party, former advisor for the Democratic Party, said their case in that court is not a case of law, it's about politics. So you can see that the approach being taken by our learned friends in that court is a political posture. And the court is taking another posture. I think we need to reset if we care about the interest of justice in that court. Because what is happening in that court is just painting us as a very, autocratic society, disorganized. There's no decorum, there's no courtesy in that court. The last thing I would want to say is this, and my good friend and colleague Aaron Kiza already is in jail serving a 9-month sentence. You can tell that the incarceration of Aaron Kiza was not about perhaps his conduct only in that court. It was much more than his conduct. Many people have argued that Aaron Kiza, he used the word belittles or abuse, but I think he furiously challenged the judge advocate in that court. He challenged the chairperson of that military court. He challenged the prosecutors, perhaps in a more louder way than his other colleagues have done so. And I think that together with the baggage he comes with, the cases he's done in the past, may have just landed him in that hot soup. I think it is most unfair, because in a courtroom where lawyers and judges disagree, the normal thing to do was to say, let's go back to chambers and sort out this housekeeping rule. And normally when you do that, you save the court image from such display. In this case, the court appears to have fallen in that trap and acted in haste, and unfortunately sent our colleagues in jail. I hope and pray that the court, Martial Appeals Court, can reverse that decision and ensure that Aaron Kiza is released and returns to do his case. Because see, the incarceration of Aaron Kiza has now added a second layer of legal challenge to the process before the General Court Martial. The accused persons are saying, that is the lawyer I want in my case. You don't have him. So you're creating another legal problem that is perhaps a sideshow. And the General Court Martial should not have gone down that route.
My last question to you, Counsel Nicholas, before I come to the Honorable. Who is at trial here?
Well, the simple answer is that the people who are on trial are the people who are charged in the charge sheet.
Because there's the UPDF Act being thrown.
But
yes.
I guess the question that you raise is that this process has shone a light on other issues, okay, that we as a country ought to have resolved so much long ago. The first, of course, is the question of the propriety of the General Court Martial, not just in trying civilians, but acting as a quasi-judicial body. Structurally, that court is not set up in a way that would fulfill the requirement for a proper judicial process. You have a court that can retire to ask for direction from this appointing authority. It's in their rules. You have a court whose membership have no legal training. You have a court whose members don't enjoy security of tenure. What gives a judge the power to make a decision is that they have a security of tenure. Nobody can remove them. It's difficult to remove a judge. But you have a panel who are appointed on an annual basis by its appointing authority. They have no security of tenure. So will that court have the independence to make decisions that sometimes might be against the interest of its appointing authority? We doubt. The second question, of course, is the issue of the trials of civilians in the General Court Martial. The Honorable Minister has said the Supreme Court should have provided guidance. The case before the Supreme Court has taken 5 years, and yet the Supreme Court has issued a temporary injunction staying the implementation of the decision of the Constitutional Court, which outlawed the trials of civilians in the General Court Martial. A system acting in good faith, okay, a system acting in good faith, this system including those who prosecute in the armed forces, should have taken judicial notice, not just in the Kabazuruka case, because there are 2 other decisions following that decision. One of them is Amon Biarogaba. The other is, I think, Lieutenant Ogwang, that outlawed the trial of civilians in military court. And those decisions have never been appealed or even stayed. So a system acting in good faith would have paused the trials of civilians in military court and waited for the guidance of the Supreme Court in regard to that matter. But what do we see? Civilians are being tried in that court making excuses, saying they hadn't been served with an order of stay of trial, and in that regard, therefore, they don't care, they will go ahead with the trial.
Thank you.
So in that regard, the court itself is under trial, but so is Parliament, because the question is, in enacting the UPDF Act in 2005, did Parliament have the authority to extend the jurisdiction of the military court to try other people who are not members of the UPDF? Because the Constitution says Parliament shall make laws to ensure military discipline in the military court, in the military, by enacting a court system. Parliament went ahead and did way over what the law requires them to do and granted that court jurisdiction, not just over civilians, but by the way, over extraterritorial crimes. So if you commit a crime of certain nature in Guantanamo, you could still be tried by General Freeman Mugabe. You still can. Okay? So the question of the legislation, and the Honorable Mao indicts academics for writing opinions in the papers, but if anybody cared to read the reports of the Human Rights Peace Center on military justice, there is numerous study written by Dr. Kawumba, written by Dr. Ronald Naruwero, who by the way has a PhD in military law. PhD in military law. They've done extensive research on the question of military justice. You'll be surprised to learn that part of the conclusion, and one of the studies I took part in and wrote for the UN Human Rights Office, is that even for military men, that court is not delivering justice.
Okay.